What was the best gotcha moment that you've seen go down in court? A lady got into a minor fender bender with a truck in a casino parking lot. She backed out of a spot into him. My guy said she had parked and went inside the casino for a few hours. At her deposition, she testified that she was so hurt that she went right home and to a hospital. I asked if she was a frequent visitor of the casino and if she had a rewards card. She was happy to tell me that she did, and she had gold status, and showed me the card. I subpoenaed her rewards card records, and it showed she was playing slots for hours after the accident. My client's house burned down from an explosion in the fuel oil tank used to heat the house. It was clearly the oil maintenance company's fault, but his homeowner's insurance, from a very reputable company, still refused to pay out, citing a ridiculous technicality in his policy. Essentially, the policy covered damage caused by the oil heater, but they claimed that it was the storage tank that exploded and wasn't part of what was covered. So they deny his claim, which was about $1.2 million, and then I get involved. During a deposition with the claims adjuster, I ask how she came to the conclusion that the storage tank was not a part, or at least not connected to the heater. She states that she relied on her expert witness, who was an engineer. Little did she know I'd already checked this person's background. He had zero engineering experience or education. As most of you might know, you don't get attorney's fees in most cases. However, when an insurance company denies your claim in bad faith, now you do. Her little admission cost the company about $500,000 in fees, on top of the original claim for $1.2 million. Plaintiff had an X-ray of an allegedly broken arm. It seemed off to me and the dates didn't make sense. I was in-house at an academic medical center. I looked at the case more closely and discovered that the plaintiff was an X-ray tech at another hospital. After that, it was all over. I was trying to get a restraining order for a woman in DV court from her son's father. We were presenting testimony and she detailed a story where he grabbed her arm and slammed it on the tub, breaking her wrist. On cross, I asked the accused if he ever broke my client's wrist on purpose. His response, "Frick yeah, I did. She was 9 months pregnant and about to do smack and wouldn't stop. I tried to grab her arm to get the pipe and protect my unborn son. Frick me." She left that detail out in her conversations with me. Well, that's a moral conundrum that could be put in a philosophy course. Actually, no, just call the cops on your wife. Sucky situation anyway, though, all told. I had a former client file for bankruptcy, and in connection with that case, brought an action against his landlord for violating the automatic stay. In order to prove the damages, he wanted to show he paid my firm for legal fees in connection with the landlord's pursuit of rent in violation of the stay. So this former client's bankruptcy lawyer serves me a subpoena to show up at the bankruptcy hearing. He didn't ask me any questions prior, but just gave me the gist of what the objective was. In this case, to verify with the court the time I spent and the cost to his client. The bankruptcy attorney called his client, my former client, to the stand first. He asked him questions related to his hiring my firm to do this and that as it related to his landlord. Apparently, that's not enough. The bankruptcy attorney wants me to verify these facts as well. I get put on the stand and I was asked to verify the invoice. I first object to the question as a precaution, since it may be a violation of attorney-client privilege to answer the question, and to cover me for any claim by the bar or my former client. As predicted, the judge overrules and orders me to answer. I review the invoice and answer, "No, this is not my invoice." His attorney says, "I don't understand. This is your firm's logo and information, right?" "Yes." "And you provided these legal services, right?" "No." A very confused attorney slowly started to put together, after a couple more follow-up questions, that this idiot client of ours had manufactured my invoice to prove his damages. Needless to say, I could have given his new attorney the heads up, but I wasn't going to help someone who'd committed perjury to the court using my name. I'd represented him in a completely different matter, and this guy was trying to make some extra cash through his bankruptcy hearing. 2 lessons. Tell your attorneys everything, and as an attorney, make sure your client feels comfortable telling you everything. Cross-examining a custom home builder who had a lump sum contract, set price as opposed to cost plus, which means cost of the materials plus the builder's fee, with the homeowner. Claimed he put 20% more labor and materials into building the home than the contract had provided for, and he was suing for those excess costs. I was asking him about an email with my client negotiating the price of the construction, and he volunteers that he knew he couldn't build it for that price. My head snaps up. Supervising partner's head snaps up and the opposing counsel goes pale. Dialogue was something like, "You quoted this price?" And the builder said, "Yes." "And you knew you couldn't build it for that price?" The builder said, "Yes." You knew the homeowner was relying on that quote. Yes. You knew the homeowner wouldn't have signed the contract without that representation. Yes. And you told homeowner's lender that you could do it for this amount. Yes. And the bank relied on that price and wouldn't have given loan if they knew it was wrong. Yes. This is textbook fraudulent inducement and he had no idea. Builder got poured out in the arbitration award and slapped the builder with a sizable punitive damages on top of it. 5 minutes of testimony sunk his case because he volunteered information without being prompted. The plaintiff alleged he was so injured in an auto accident that he couldn't work or do any regular activities or pick up his young kids. He then posted on his public Facebook profile him doing the ice bucket challenge. If you're not familiar, he basically lifted a huge cooler filled with ice water over his head. His attorney had no idea that he'd posted it. I once heard about a man who got a doctor to do him a report for his compo claim. Can't bend, can't lift, can't run, etc. Problem was he had a paternity suit ongoing at the same time. Got the same doctor to write a report for that case. No restrictions on mobility, can pick up kid, play with him, etc. As you can guess, he and the doctor got caught. Recent and pretty good, I represented a guy whose car died in the middle of the freeway at 4 a.m. He put his hazard lights on and called 911 for help. At the same time, an LAPD cop heading to work around the same time in a police unmarked car was driving around 87 to 92 miles per hour. Per our deconstructionist, he didn't see our guy and strikes him, causing a major 6-car collision, including overturning an 18-wheeler truck. The police arrive and take photos. The LAPD officer claimed our guy didn't have his hazard lights on, and he was only driving 60 miles per hour. He was trying to put some of the fault on our guy. At the deposition of the investigating officer, she doesn't remember if our guy's hazard lights were on or not. The attorney brings him photos of the scene. One of the photos showed my guy's hazard lights on. We were dismissed shortly thereafter. Not so much a gotcha as it is the defendant giving themselves up. When I worked for insurance defense, I handled a fraud case where a man reported his Rolex as being stolen. He was so adamant that he was at a hotel and it was stolen. He's shown no proof of being in a hotel, so it's flagged. We go through the whole process and finally reached depositions. He gets sworn in and eventually left out that he wasn't at a hotel, but rather with his mistress and had left it at her house. His wife noticed he didn't have it on, so he immediately claims it was stolen. Yeah, right. This man decided to hire an attorney and go through this whole circus just so his wife wouldn't find out about his affair. Needless to say, the claim was denied. I mean, the fellow in question is a gigantic sack of crap, but I guess if he wants to save what's left of his marriage, that's clearly failing by his own fault, go ahead. Lying always works, right? When I was in the military, I was accused of something I didn't do, and I had to go to court over it. And during court, the prosecutor started to detail this investigation and how they'd staked my apartment out for months. They entered into evidence a picture of my apartment, and when they put it up, I looked shocked at my lawyer because it wasn't a picture of my place. It was my ex-wife's apartment, a place I'd never lived, never spent a single night there. I lived in a house, she lived in an apartment. And when my lawyer asked if she objected to the picture being entered into evidence, she replied, "I don't mind them entering it into evidence as long as they change the listing of it." And when one of the members of the panel, no judge, 3 members board, asked what was wrong with the listing, she looked at him and said, "That's not his apartment." On top of this, the witness they used against me described going to my house on the night in question, and she named the subdivision where she had visited me, except that wasn't where I lived either. Also wasn't where the picture they had was either. The case was dismissed and I was told they requested the witness to return to answer questions about perjury. I lived with a guy when we were in our early 20s. He worked for one of those crappy furniture rental places where people without money get furniture. Much of his job was repossessing furniture, and in his spare time he was a skateboarder. He severely hurt his back on the job and they were contesting paying his bills and settling. At one of his mediation dates, they revealed they'd hired a private investigator to follow him. They showed him pictures of himself at a skate park skating when he was supposed to be home recovering. They asked him to verify it was him. He said no. These doofuses had somehow missed that he had a twin brother who also skated. They eventually settled for what I thought was a very low $70,000. He had back pain for years that caused him to gain weight and suffer. In his 30s, he finally had back surgery and he regretted not doing it 10 years earlier. He said it completely alleviated the pain. I had a client accused of leading the cops on a high-speed chase. The cop on the stand estimated he was going 90 miles per hour but never actually clocked him. Then the cop identified where the chase started with me and where it ended. It lasted about 2 miles. Then we went through his log of when it started and when it ended. About 3.5 minutes. Once you walk through the math on that, the average speed of this chase was 35 miles per hour. The client got acquitted really quickly after that. A friend of mine got pulled over once. I was in the car with him. When the cop approached us, he said, "Do you know how fast you were going?" I had to go 70 to catch up. My only thought was, how does that matter? It's not like he'd catch up by matching our speed. I'm still confused by that interaction. It sounds like police officers don't know what relative velocity is. The first case I ever did, opposing counsel misplaced the copy of my client's driver's license. Rather than admitting his mistake and asking me to resend it, he filed a motion to compel, claiming we never sent it. Well, I was able to provide proof that we'd sent it to him like 8 months ago, so the judge was rather displeased with his antics. The judge was rather displeased with his antics? Not a lawyer, but this tends to be my impression with judges who catch people doing shady stuff. I remember once, during undergrad, being an intern with a probation office, and the case ahead of our revocation hearing had a guy pleading guilty. During his rambling and disjointed allocation, the judge frowned. "So why are you pleading guilty exactly?" And the guy replied, "My lawyer told me to." The judge was most displeased when he questioned the guy further and found out the guy had no concept of what he was doing or what the potential sentencing could be. You can submit your own stories to be featured here on the channel. The story submission link is in the description below. And if you want to listen to some vibey music in the background, check out Easy Mode, also linked below, and subscribe. Represented a DUI client who swore up and down to me that he hadn't been drinking or doing any substances. A newbie officer who had his field training officer with him in the car. The rookie pulls the client over for a tag violation, walks back to the car with the body camera still on, and the training officer, FTO, says to him, "Get him out for a DUI," and the rookie says, "But he's not intoxicated." To which the reply was, "Do it anyway." The body cam clicks off, turns on 7 minutes later when they're doing field sobriety exercises on my client. The client sat in custody for 3 weeks until I finally got the tape from the prosecutor and presented it to the judge. The "oh crap" looks from the prosecutor and field training officer when the judge saw the tape, I'll treasure those. The judge wrote the police chief a letter saying the field training officer was dead to him and he'd deny every search warrant he tried to bring thereafter for being a liar. The client is hopefully still on track with his civil attorney in a lawsuit. I was suing a landlord who failed to make serious repairs in order to force the tenant out. The hard part is proving bad intent instead of mere idiocy, so you get higher damages. Code enforcement was involved, so I request those records. The landlord left a voicemail to the enforcement department saying to hold off on the fines. They'll make the repairs as soon as the tenant is forced out. That was an easy case. Some crap like this happened to my dad. The landlord refused to make repairs, the washer was busted, garbage disposal was leaking, and forced floorboards to warp. My dad moved and wanted his deposit. They wouldn't give it to him. He took them to court. He took pictures before he left and kept all texts from them. They walked themselves into a corner with everything they said. My dad was prepared for every claim. Eventually, the judge told my dad he could fight it until the end and get his whole deposit, or the landlord could give most of it now and it would be over. He took the deal because he didn't have time for court, and the look of anger and defeat on the landlord's face was too satisfying. I had a client whose $60,000 car was ruined by a shop that put in the wrong oil. We couldn't prove it at first. The engine blew up and oil leaked out and evidence was lost. I subpoenaed their bank records. I figured out they brought their oil from Costco. Called Costco and got their prices list for the last 2 years. I worked out the amounts they were spending, did some backhand math, and showed, based on the values, it was impossible they ever bought the correct oil. They settled in full immediately. This is just satisfying. Not a massive slip-up on the defendant's behalf like a lot of these others, just a good bit of clever sleuthing and voila, the magician has turned a "this didn't happen" into a "we admit everything." Chef's kiss. Worked as a paralegal and investigator. Working a trade secrets case involving the manufacturer of dental wheels used to grind teeth. Long story, but go with it. Company A was a small family-owned manufacturer, but made the best product on the market from a small factory in the middle of nowhere. Sold massive amounts of product because of quality. Its location was remote enough and the owner paid employees so well the employees stayed there. Forever. All of them had worked there for more than 30 years. When the founder of the company died, it was sold to International Company B because the kids and grandkids had no interest in the company. Company B then closed the old factory and tried to use Company A's formula at their facilities. Company B couldn't make the formula work. Now, enter Company C, another international company who lost the bid on buying Company A. When Company C heard about the problems Company B was having, they brought the old factory facilities and then rehired the old staff to restart production. All the employees of old Company A were delighted to have their good-paying jobs back and went straight to work, producing the better quality items once again, and Company C's product worked. Company B sues Company C for trade secrets violation. When you buy a company, you buy their trade secrets, and this company had a bunch. The product was just one part, but the most profitable part of their operation. Thus, Company C, because of their action, was accused of violating the laws governing trade secrets. Company B even managed to get a temporary restraining order against Company C in federal court, and Company C had to stop manufacturing at the old plant they now owned. This is when I enter the picture. Our firm represented Company C, and I was assigned to interview all of the employees. I was in the living room of this delightful older lady in her late 50s that offered me snacks and asked me if I was married and wanted to set me up with her granddaughter, you name it. Best and funniest interview ever. Then she drops the bomb. I asked her how she knew how to make the product. All my previous interviews said so, and so taught them. She said, "From the directions on the wall." Total moment of silence. Directions on the wall? "Yes," she said. "No one ever looks at them, but there's a board on the wall with the directions." I called the janitor of the facility from her phone. Yep, this is before cell phones, and had him meet me there. He unlocks the place and yep, covered in probably 40 years of dust, making it just part of the background, is a board with the entire process on it. Thus, when Company B sold the factory, which was eventually purchased by Company C, Company B accidentally sold the trade secrets to Company C because they abandoned it on the wall. I did serious evidence sourcing on this. My best pictures were of this 65 or older former janitor knocking the dust off the pages, taking the entire board off the wall, putting it in a paper bag and sealing it so I never touched it. Every picture he smiled for the camera. His "frick you" expression was priceless in every picture. They were so fricking funny. The judge in federal court was laughing his butt off when he heard the details of what I found to reverse the restraining order. When he opened the bag, he laughed even more. The factory reopened immediately. Company B and C settled by agreeing that they both got to use the trade secret, but couldn't sell it to anyone else. What they really figured out was those little old ladies had slightly changed the formula over the years and made them slightly better over time. Even the formula on the wall didn't work as well as those little ladies did. My brother is an attorney. He had a case where the guy said he was permanently disabled from a work accident. At a deposition, my brother overheard the guy talking about getting his house remodeled. He was already spending the money he thought he was getting. My brother drove by the house to see how much work was being done and saw the guy carrying bundles of roofing shingles up a ladder to the roof. This was before smartphones, so he drove to a Best Buy and brought a video camera, went back and recorded the guy. He had copies made and sent it to the other attorney. The guy dropped the suit and went back to work the following Monday. My brother's client didn't want to pay for the video camera. It saved them thousands of dollars. They eventually paid, but he still gets a little teed off when he talks about it. I'm amazed the initial guy's company even took him back after he tried to pull that stunt. Certainly wouldn't have helped his chances at future claims. Sucks to suck, although clearly his bosses sucked a bit too. Legal videographer. This gentleman was claiming injuries and seeking damages against his employer after a fall at work. He claimed he couldn't raise his right arm above his shoulder because of the fall. First deposition comes along and I'm hired by defendant's attorney to videotape deposition of the plaintiff. Anyone know the first thing a court reporter asks you to do in a deposition? Please raise your right hand and repeat after me. The plaintiff raises his right arm above his shoulder with ease and no sign of discomfort. It doesn't occur to him what he's done. Both attorneys were looking down at their notes when this happened and neither of them caught it. The plaintiff himself didn't catch it. The court reporter looked at him and then looked at me, and her eyes went wide with realization at what had just happened. 4 hours of depositions proceed where the plaintiff is instructed, multiple times, to show his range of motion and proceeds to pretend like he can't raise his arm above the shoulder level, which he did at the very beginning of this deposition. Deposition ends, plaintiff's counsel leaves, I call defense, the hiring party counsels over, and show them the first 2 minutes of the tape. The counsel excitedly whispers to me, "Case closed. You've just saved us tens of thousands of dollars." I got a $5,000 bonus and the plaintiff's case was dismissed with prejudice. This is so petty. I've had much bigger moments, but because of the character of the other side, this will always be my favorite. Doing a boundary dispute. A squabble over what was essentially a few inches of land. The other side was a lawyer and an absolute butt. He was acting for himself. The whole, a lawyer who acts for himself has a fool for a client thing was bang on for him, but he was a deeply unpleasant guy, a bully who thought that he was the smartest guy in the room. Part of his case hinged on wheelie bins and how prior to the boundary having been moved, there wasn't space to store a full-sized bin beside the house. The fact that you now could meant clearly the boundary must have moved. That was the extent of his evidence. It was really thin stuff. During the actual trial, he pulled a fast one by suddenly producing an old aerial photo, ostensibly to show the boundary at the front of the property had also moved. A fast one because you have to disclose stuff like that in advance, you can't just sit on something relevant and then suddenly whip it out at a trial with a flourish. While he was making his submissions that it should be admissible, I looked more closely at it, away from the bit of the boundary he said it was relevant to, and realized that it very clearly showed a wheelie bin in exactly the spot his case said there couldn't be one. Told the judge we were happy for the photo to be admitted after all, and got the other side to confirm the date it was taken, and then pointed out he'd just completely messed up his own case. That photo did him for nearly $50,000 in adverse costs. Couldn't happen to a more deserving chap. My client was a woman working at a meatpacking plant. Her glove, they'd only give her the loose kind because they were cheaper, got caught in the machine and she lost her arm. We sued the owners of the plant for the glove issue. We also sued the machine manufacturer for failing to include the required guard. Then we sued the distributor for being in the chain of the sale, but didn't really think they played that much of a role. The manufacturer swore that they included a handguard and said the plant owner must have used a grinder to take it off. During a deposition of the guy that owned the distributing company, he shows up with the sale documents he was supposed to have turned over weeks before. Turns out there was a note in the small print at the bottom he didn't know about that said the sale was without the handguard, which is against the law. I pointed it out and we ended up settling that afternoon with the distributor. The woman got all her medical bills paid, got money for a prosthetic, and got a bunch of pain and suffering damages. When you subscribe, make sure to hit the bell to turn on notifications. Put the playlist on in the background to finish listening to all the stories, or if you want some vibey music to put on in the background, check out Easy Mode. If you like Am I the Genius, give Am I the Jerk a shot. Everything linked in the description.